There was a cane on the evidence table, white shaft, black grip, blue tape wrapped near the tip because the rubber had split and somebody still needed to use it before a new one arrived. I have seen knives, ledgers, photos, broken phones. I still think about that cane. I could see the mark where a tire had pressed over the taped section. Not enough to crush the whole thing, enough to tell me how close that vehicle came to the hand holding it. That small mark is why I am telling you this now. I had the file open in front of me when I looked at it again. I already knew the date. I already knew the time. I already knew the words the defendant had said in that parking lot. What I did not know yet was whether she understood that a name can become a weapon when a person uses it to make someone smaller. Subscribe to this channel. I do not say that lightly. I say it because if you are still listening at this point, you are exactly the kind of person who should hear what comes next. Subscribe. Then I will keep going. The woman who came into my courtroom with that cane was Helen Morris. She was 58 years old. She worked part-time at a library branch and 2 evenings a week at a church pantry. She did not enter like someone asking to be carried by the room. She entered like someone used to crossing rooms that were not built with enough care. What stayed with me about Helen was her discipline. She answered exactly what I asked and nothing more. When her lawyer handed her a bottle of water, she turned the label seam inward before she set it down, as if she still wanted things orderly. During testimony, she said, "I did not need her to like me. I needed her to stop." I wrote that down. The defendant was Caroline Mercer, 34 years old, vice president of marketing for her family's dealership chain. She wore a cream blouse, a dark skirt, and a watch she touched whenever testimony moved too close to the part she did not want to hear. Her posture was very straight, not from fear, from practice. From the bench, I watch people when they think attention has moved elsewhere. Caroline looked at me when I spoke. That was smart. But when witnesses spoke, her eyes went to the gallery, then to the clerk, then to the door. When the exhibits were carried in, she looked at the cane for less than a second. She looked longer at the envelope that held the photos of her SUV. By the time the case reached me, I knew more about the afternoon of April 16, 2024 than I ever wanted to know. The incident happened at 5:38 p.m. outside Harbor Pharmacy on Atwells Avenue in Providence. Clear weather, good light, fresh blue paint in the accessible space and in the striped access aisle beside it. Those stripes mattered. I want to say that plainly. Most people think the parking space is the whole thing. It is not. The striped aisle next to it is part of the space. It is the room needed for a wheelchair, a walker, a cane, a safe step down, a safe step back up. Blocking that striped area is not almost legal. It is blocking access. Helen Morris parked lawfully at 5:26 p.m. The pharmacy receipt showed she was inside for 11 minutes. Caroline Mercer arrived at 5:34 p.m. in a white Range Rover Sport and stopped across the striped aisle because the regular spaces were full. A clerk named Luis Ortega said he saw Helen come out first and stop at the curb ramp. Caroline was locking her car at the same time. Helen said, "Ma'am, I can't get through there safely." Caroline said, "It'll be 1 minute." Helen said that was not enough room. Then Caroline said, "Do you know who I am?" Those words came into my courtroom through 3 witnesses and a phone recording. The first person to repeat them was Helen. The second was Luis Ortega. The third was Brianna Cole, a college student waiting in her own car for a prescription pickup. On Brianna's recording, you could hear traffic, cartwheels, a car door, and then Caroline Mercer saying, clear enough for me to hear it twice, "Do you know who I am? I'm going to tell you something that did not come out until the 3rd day of testimony, something that made me stop and ask the witness to repeat it. If you are not subscribed yet, do it now, because that moment is coming and I do not want you to miss it." What happened next came to me in pieces. Helen did not try to force herself through the gap at first. She waited. She stood with her pharmacy bag in one hand and her cane in the other. Luis Ortega came to the door and told Caroline her vehicle was blocking the access aisle. He said Caroline answered, "I said 1 minute." That was in his statement the night it happened, and he said the same words again under oath. The problem with 1 minute is that it always belongs to the person saying it, not to the person forced to stand there and spend it. Helen waited while 2 other customers came out and walked around the rear of the SUV. She could not do that safely without stepping off the curb line into moving cars. Helen said she tried again. She said, "Please move your car. I can't see the edge from here." I noticed that sentence because it was precise. She did not exaggerate. She did not say she could see nothing. She said she could not see the edge from there. Precise people often tell the truth in precise ways. At 5:37 p.m., Caroline came back outside with a small pharmacy bag and a phone in her hand. Brianna Cole said Helen repeated herself. Caroline said, "I am already leaving." The exterior camera showed Helen near the curb ramp in the front of the SUV, still angled over the striped space. Then Caroline got in. Then the brake lights came on while Helen was still standing there. This is where the case changed. Caroline backed up before the path was clear. Not fast. I want to be exact about that. Not fast. But not careful either. The right rear tire rolled over the lower section of Helen's cane after Helen lowered it to find the curb edge. Helen jerked backward. Her pharmacy bag dropped. A bottle inside broke. She struck her left wrist against a metal post by the ramp. The SUV stopped. Then it moved again. That second movement mattered. The defense spent a long time asking whether Caroline knew she had hit the cane. I considered that fairly, but even if I set that aside for a moment, I still had the second movement after people were yelling. Brianna said she shouted, "Stop the car!" Luis said he shouted too. On the recording under the traffic noise, you hear a woman say, "She's right there." Then, very near the phone, you hear Caroline say, "If she can stand there yelling, she can walk around." That was a quiet sentence, still wrong. Nobody had to tell me what it meant. I wrote it down exactly as I heard it. The first paper that crossed my desk was not a criminal complaint. It was a city citation for obstructing an accessible access aisle. That is more common than people think. What was unusual here was what came with it: photos, witness statements, a body camera summary, and a request from the prosecutor to add reckless operation in a public lot and disorderly conduct. Most people do not know this, so I will explain it the way I would explain it at my own kitchen table. A case can begin with a small local violation and still grow if the facts show more harm underneath it. The first charge opens the door. The later evidence tells the court how wide that door needs to swing. I remember the first morning both sides appeared. Helen came through the left door with her sister, Miriam. She kept the cane folded until she reached counsel table, then opened it with one clean motion and laid it beside her chair. She did not look toward the defense table. Miriam did once, then sat down and pressed her mouth shut so firmly that I noticed it from the bench. Caroline came in through the rear side door with her lawyer, Daniel Talbot. She carried a leather folder and a phone she handed to him before she sat. She moved quickly but not nervously. She turned to a man in the second row, whom I later learned was her father, Thomas Mercer, and said something I could not hear. Then she faced forward. The first wave of evidence gave me the baseline facts: time stamps, parking lot photos, the pharmacy receipt, the exterior video, Officer Jenna Ruiz's body camera footage from 5:49 p.m. Helen's wrist was already swelling on that video. The cane was on the ground by the curb. Officer Ruiz testified that when she asked Caroline why she parked there, Caroline said, "I was in a hurry." Then she said, "I did not think it would matter for a minute or two." During that first wave, I kept watching Helen's left hand. Every time a photo of the lot went up on the screen, she rested that hand over the sore part of her wrist, not gripping, just covering. People do that when they are trying to quiet one part of themselves so the rest can stay steady. The second wave complicated the case the way real cases often are complicated. A defense witness, Michael Barr, said both women sounded angry by the end. I believed him on that point. Another defense exhibit showed Caroline had received several calls from St. Anne's Oncology Center that afternoon, where her mother had been in treatment that week. That mattered. Pressure is real. Family fear is real. I took both seriously. Daniel Talbot argued that the lot was cramped, that Caroline believed Helen had stepped back, and that the second movement of the SUV came from panic after people began shouting. He also said the city was trying to turn a parking dispute into something larger than it was. He had every right to argue that, and I listened closely. But pressure does not repaint blue lines on asphalt. Fear does not create room where there is no room, and one detail kept drawing my eye. Every time the defense talked about timing, Caroline tapped the face of her watch once with her right index finger, as if time were still hers to assign. I want to stop here for a moment, because what I'm about to tell you is the part of this case that took me the longest to speak about in public. Subscribe before we go further, then take a breath, because this next part matters. The third wave of evidence answered the question the defense wanted left open. Did Caroline know enough, soon enough, to stop and correct what she was doing? The answer came from Brianna Cole. She was 21, tired, honest, and not polished on the stand. I trusted her more for that. On the third day, she testified that after the first shout, before the SUV moved the second time, she heard Caroline speak from behind the driver's side window. I asked Brianna to repeat it. She said, I know, I'm going. Then Brianna said she heard the tire go over something, saw Helen jerk backward, and heard Caroline say, she'll be fine. None of that sounded rehearsed. It sounded like a young woman telling me what she wished she had never heard. The audio recording did not carry every word clearly, but it carried enough, and the law does not require one perfect piece of evidence if several separate pieces line up and support each other. Caroline Mercer testified in her own defense on the fourth day. I always watch closely when a defendant takes the stand. She said she never meant to frighten Helen. She said she was trying to get back to the oncology center before her mother was discharged. She said, I was trying to leave, not start something. I believe that part. I do not think she went to that pharmacy hoping for a scene. Then her lawyer asked whether she had meant to use her family name to get special treatment. Caroline paused. She looked at him, then at me, then at the cane. She said, people hear my last name before they hear me. I wrote it down. It was meant to sound wounded. It told me more than she intended. Later, on cross-examination, the prosecutor asked why she said, do you know who I am? Caroline answered, I was frustrated and I said something stupid. That was closer to the truth. But then she added, I did not think it would become this. I wrote that down too. Not what I did, what it became. That difference mattered. Subscribe if this is the kind of story you want more of. That is the whole pitch. No speech. Just subscribe if it is for you. While I listened to all of this, a memory from my own life kept returning. I was 12 years old, standing beside my mother outside a grocery store. She had 2 paper bags in her arms and a bad knee she never liked to mention. A driver climbed partway over the curb to save a few steps. My mother pulled me back so hard my shoulder stung. That night, while putting bread on the kitchen table, I saw her hands shake once before she flattened them against the wood. I did not think about that moment for years. I thought about it again while Helen Morris testified. By the time closing arguments ended, I had made my decision. I had made it, if I am honest, before the last half hour of testimony. But I still listened to every word. A judge owes that to everyone in the room, even after the facts have settled in the mind. The courtroom was very still when I began. Not still in the way people talk about from outside a courtroom, still in the way I know from the bench. No papers moving, no chair legs shifting. Even the clerk's fingers were off the keyboard. Helen had both hands around the handle of her cane. Carolyn had her palms flat on the table, shoulder width apart, as if holding herself up against something heavy and invisible. I found Caroline Mercer guilty of obstructing an accessible access aisle, guilty of reckless operation of a motor vehicle in a public parking lot, and guilty of disorderly conduct. I said each count plainly. Then I explained why. I said the witness accounts were credible, the physical evidence supported them, and Caroline's own statements showed awareness and disregard. The first reaction I noticed was not Caroline's, it was Miriam's. For 4 days, she had sat with her hands locked together. When I said guilty on the final count, she released her own fingers and placed one hand between Helen's shoulders. Just once. No tears, no sound, just that touch. I am telling you this story because I believe it needs to be told. Subscribe if you believe the same thing. That is all I'm going to say about it. Then came sentencing. The defense asked me to consider Caroline's clean record, her employment history, and her family circumstances. Daniel Talbot argued that public humiliation would serve no lawful purpose and that a fine plus probation would be enough. I agreed with him on one point. Sentencing is not revenge. If it is only anger in formal clothes, it is a bad sentence. I also had Helen's records in front of me. A left wrist sprain, 8 weeks of treatment, therapy notes describing fear in public parking areas afterward, invoices for a new cane, ride services for 6 weeks, and missed work hours at both the library and the pantry. Not large numbers by the standards of some courts. Large enough when they fall on one person because another person decided 1 minute mattered more. Caroline spoke before sentence. That was her right. She stood and held the table edge with both hands. She said, "I'm sorry for how that day looked." Then she stopped. I waited. Then she said, "I was trying to take care of my mother and I handled it badly." There was truth in that. There was also a limit in it. I had the pen in my hand. I had already written the number down. I just had not said it out loud yet. The verdict was not the hardest part of this case for me. The sentencing was. Because sentencing is where I had to decide not just what was legal, but what was right. Subscribe so you do not miss what I decided. I am getting to it now. I looked at Caroline Mercer and said, "In this courtroom, the answer to, 'Do you know who I am?' is simple. No one above the law." Then I said, "I am ordering you to pay a financial penalty of $12,500 to the Rhode Island Center for Independent Living Access Fund. I am doing that because the harm in this case did not stop with Helen Morris. Conduct like yours narrows public space for every person who depends on that space being open." I said, "I am also ordering an 8-month suspension of your driver's license, effective immediately. During that time, you may not operate any personal vehicle, any company vehicle, or any vehicle registered through Mercer Automotive Group without prior written approval for a documented medical emergency. I am doing that because driving is not only movement, it is judgment. And on April 16, 2024, your judgment failed where care was required most." I said, "I am ordering 160 hours of community service, 100 hours with the Rhode Island Center for Independent Living Accessibility Support Team, 60 hours with the city's driver safety outreach program. I am doing that because education after harm should not stay abstract. You need to spend time where access is not a slogan." Then I said, "And there is one more thing. You will prepare a written apology subject to my approval, and you will read it aloud at 3 public driver education classes in this county within 6 months. You will include Helen Morris's name. You will include the words you said in that parking lot. You will explain what the striped access aisle is for. I am doing that because some lessons should be spoken in public." I was not done. I said, "I am also ordering restitution in the amount of $7,840.60. That covers medical copays, therapy, transportation, a replacement cane, and documented lost wages. I am doing that because apologies do not pay invoices. The cost of your choices does not belong on her kitchen table." After sentence, I spoke to Caroline directly. I said, "What you did cost Helen Morris money, treatment, confidence, and the simple right to cross a marked piece of pavement without bargaining for it. It cost her 6 weeks of rides she should not have needed, and a cane she had already learned to trust." Then I said, "Your family did not put you in this chair. Your choices did. They will carry their own burden from this, and I say that as fact, not as accusation." Then I said, "Privilege is not a pass. It is a duty to listen sooner, move faster, and make room when someone else cannot." And I ended with this: "I believe you knew, in the moment that mattered, that Helen Morris needed space more than you did, and you chose yourself anyway. Thank you for staying with this. I mean that. I know this is a long story. I know it is not easy. Subscribe if you have not yet. You already know why you are still here. When the clerk began the paperwork, I stayed on the bench. I do not rush those first seconds after a sentence. They tell me things." Caroline did not cry. She sat down slowly, as if she had forgotten the chair was there. Her father leaned toward Daniel Talbot and said very quietly, "We'll appeal." Daniel nodded and stacked the papers into neat piles. Helen did not turn around. She stayed facing forward. Miriam bent to pick up a receipt that had slipped from Helen's folder and handed it back to her. Then she said, "We can go now." Helen answered, "In a minute." It was almost a whisper. I still heard it. As the room began to empty, Officer Jenna Ruiz paused by the rail and asked Helen, "Do you need help to the elevator?" Helen said, "No, I know where it is." Then she stood, set the new cane on the floor, tested the first step, and walked out with Miriam half a pace behind her. The room felt smaller when they were gone. The appeal was filed 18 days later. It went to the Rhode Island Superior Court Appellate Division. The defense challenged the sufficiency of the evidence, the sentence, and the public reading requirement. On December 3, 2025, the panel affirmed the convictions and the sentence in full. The ruling said my factual findings were supported by the record and that the sentence was tied to the conduct, the harm, and the public interest in access. It took just under 11 months. I was not surprised, but I was relieved. Later, I learned two things. On August 12, 2025, before the appeal was decided, the Driver Safety Program sent notice that Caroline had completed the second of the 3 required public readings. The director added one line that held my attention. He said she arrived early and asked that the accessible seating signs be moved closer to the front because people should not have to ask twice. Then, on September 18, 2025, Helen sent a short note through the clerk's office. It did not ask for anything. It said, "I went back to Harbor Pharmacy by myself today. I used the ramp. I stood there for a second. Then I kept walking." Under that she wrote, "I thought you should know." I still cannot answer the question this case left me with. What does a person think they are saving when they ask, "Do you know who I am?" Time, pride, control, fear. I do not know. I only know that the sentence is rarely about identity. It is usually about exemption. If you are someone who has stood at a curb, a counter, a doorway, or an elevator and felt another person treat your need as an inconvenience, then you know the feeling I saw in Helen Morris's face. It is not only fear, it is the work of deciding whether asking again will make the room smaller. I saw that. I want you to know I saw it. And if you are someone who has ever felt your title, your money, your family name, or your urgency rise into your throat before patience did, I have one question I wanted to ask and could not. What are you so afraid of losing in that moment, that rank feels easier than decency? The next time that feeling comes, do one thing first. Move, clear the space, then speak if you still need to. I come back in the end to that cane, white shaft, black grip, blue tape near the split tip because life does not always break at a convenient hour. I think about how small it looked on the evidence table and how much of the case was sitting inside that one object. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you leave a comment, leave it like someone who understands that the people in these stories are not symbols. They are where people who care about the same things find each other.